Hello, this is Matt on the Moon Lambo channel. Is the legal status of XRP still in danger? Is that a big question mark right here? Are we supposed to be worried, having trouble sleeping at night? Because I'll tell you what, there's no shortage of people out there that would have you believe that, a terrible day of reckoning for XRP holders will be upon us at some point in the future. And in fact, to that end, look at this tweet from Fox Business journalist Charles Gasparino, which comes amid new XRP legal concerns. He wrote, "If the XRP army wants to go down the Judge Rakoff is irrelevant rabbit hole, it will be its Waterloo." And he's referencing something I'm going to assume that most of you are familiar with at this point. There's a separate case with Do Kwon, the founder of Terra Luna, and that's what's set off a crypto winter in May of last year with the collapse of that, and then 3 years capital, and just the whole 9 yards. You guys know all that. Well, there's an SEC suit against covering that whole thing going against Do Kwon, and the judge specifically cited the SEC v. Ripple case, and in part went against what Judge Torres had to say. Now, and the reason that happened, by the way, is because Judge Rakoff didn't bring it up on his own. It was referenced in a legal brief in which Do Kwon was trying to get the case thrown out, trying to have it dismissed. But here's the thing. Whatever this judge wants to say in this unrelated case is not legal precedent in any sort of capacity. It doesn't actually change anything. XRP's already been relisted. But that's not the point. We already know that, right? So the question is, because there are a lot of people that are pushing this idea, is XRP, is this the legal status of it actually going to change in the future because Judge Torres actually got this thing wrong? And so that's what Charles Gasparino is getting at here. So I want to highlight that, and then I want to cover also one completely unrelated topic, which I'll be quick with at the beginning part of the video. But before expanding upon this any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, one quick little housekeeping thing for me. I put out a video in which I highlighted the post that's on your screen. The screen is definitely not a word. Here's a post on the screen from Hugo Fillion. He's the founder of Flare, and I don't need to read the thing. I covered it in a video yesterday. I have one new piece of information that I want to share with you, just my perspective anyway, which I absolutely intended to cite in the video where I covered this yesterday, and I think it's very important, which is why I want to take just a moment to cite this. I'm not going to read the post which is on your screen right now since I did in a previous video. Just know that what he's citing here, I think it's just completely wrong. Nothing against him, but I think it's completely wrong. He's basically asserting that XRP, the reason that it dumped after the positive ruling regarding the legal status of XRP. He says that it dumped because, look, XRP, the price is supposed to move in tandem with Ripple because that's the primary use case. XRP is a bridge currency, and I'm paraphrasing here, of course. And he says that Ripple is absolutely they've been having trouble growing on-demand liquidity utilizing XRP because of the lawsuit, so they have a 2.5-year setback. That's why it is what it is. That's why we see the price of XRP where it is. It's because Ripple came across hard times, and they didn't grow out their business. Okay. That's absolutely not true. So I went in depth to a certain degree, just noting that when it comes to price action of XRP, I did mention this yesterday, so I'll just say it once here. XRP moves in tandem with Bitcoin. It has never been the case that any amount of positive headlines from Ripple would cause the price of XRP to go up. Much to the chagrin of those in the community. I remember this back as early as 2017. There are those in the community, I don't know how many of them, but there were people, I observed them on social media, very dissatisfied. Like, I don't get it. Ripple's saying all these positive things, but the price of XRP isn't going up. Right, because XRP follows the price action of Bitcoin, broadly speaking. In a general sense, that's absolutely unquestionably true, right? But beyond that, I also wanted to highlight that he is incorrect when he says that Ripple had some sort of, from a business perspective, a major setback in the adoption of on-demand liquidity utilizing XRP as a bridge currency. It's absolutely not true. And so there's this article, this is from July 30th of last year, from the Daily Hodl. It was covered by all sorts of crypto media outlets, though. The headline is, Ripple's XRP-powered cross-border payment product sees 800% growth despite ongoing SEC lawsuit. And so what you see is the rest of the world, outside of the United States, no country gave a damn about the legal status of XRP in the United States. None of them gave a damn. RippleNet was growing like crazy. On-demand liquidity was growing like crazy, utilizing XRP as a bridge currency. 800% growth in the middle of this lawsuit. So he's absolutely incorrect about that as well. And so I just wanted to highlight that because this is the piece of information that I meant to share in that video yesterday, and it was bugging me that I didn't. So I just want to take just a minute or two here to cite that. That's absolutely incorrect what he's stating here. So where did we see pain? Where did Ripple see pain? In the United States. They lost customers in the United States. On-demand liquidity corridors touching the United States shut down. And so that was a disaster, but look, the rest of the world didn't give a damn. And even if you're talking about just trades of XRP at the time of the lawsuit, it was something like 5 or 10% of all transactions. I can't remember which it was. It was only 5 or 10% of all global transactions that occurred in the United States. So even with that greatly diminished, you still have the rest of the world. So I just respectfully disagree with him. I think he's missing the mark on a factual basis, and I just wanted to set that record straight. Now on this, the primary topic, which is what I'll spend the rest of the video talking about, I just want to note that, in citing how Howey applies to institutional sales of XRP, when Judge Torres is citing this, and versus programmatic sales of XRP in her decision, Judge Torres was using the language of the SEC. That's what she had to address, actually, in order to properly do her job. So the idea that doing so means that her decision risks being overturned is absurd. And I've already shared perspective from Attorney Hogan in the past. I've shared perspective from Attorney John Deaton in the past. But there's this additional reason, and this was shared by Attorney Bill Morgan. And I came across this most recent thoughts on this yesterday morning. Although for me, I think I'm just going to pull on nighter at this point. It's, what time is it? 3:29 a.m. Central Standard Time. I think I'm past the point of where I'm going to go to sleep. I think I'm going to pull on all night. But the reason I mention that even is because for me it still counts as today. Until I go to sleep, it counts as today. Which means if I'm pulling on all nighter, then today counts as 2 days. I guess I don't know. But anyway, so I saw this tweet from Attorney Morgan, and he said, "Complete silence from Charles Gasparino and the Torres critics. Must be hard to accept her approach was based on the SEC's own differentiation of the types of sales into 3 distinct categories, hoisted on its own petard." And so I went through this link, or through the thread rather, and so did Attorney Deaton. In fact, Attorney Deaton also retweeted this, and he said, "Excellent thread explaining that Torres didn't make a distinction between the different sales out of thin air. She took each type of sale chosen and defined by the SEC and applied the Howey test. I'm willing to bet significant funds she doesn't get reversed on appeal." And so then you have the Charles Gasparinos of the world saying things like that, he used the term for acutely witless. He said that Judge Torres is acutely witless in stating that sometimes XRP is a security and sometimes XRP is not a security. But that is not what she stated. She looked at what the SEC was asserting and did her job. And this is what Attorney Morgan breaks down. And this is why I'm saying, when it comes to the appeal stuff, and I don't want to rehash all the stuff that was shared previously by Attorney Deaton and Attorney Hogan, though obviously great points, here's another reason that things aren't going to be looking so good for the SEC if they actually want to keep pushing at this, if they actually want to do this. And I don't know if they will. Maybe they do, maybe they don't. I don't think it goes well for them if they do, though. And so here's what Attorney Morgan had to say. "The more I read the Torres decision, the more I struggle to see the error. The source of the error cannot be the different treatment of the 3 categories of sales. As Torres noted, it was the SEC who categorized these 3 types of sales." And he shared the screen grab from the Judge Torres ruling. And it reads as follows. "The SEC alleges that Ripple engaged in 3 categories of unregistered XRP offers and sales." And so there you go. There are people like Charles Gasparino, and there's also a lot of Bitcoin maximalists and just attorneys who in general never liked XRP, and so they're just wrong. And they're really just getting at this idea of Judge Torres. It's completely irresponsible, ridiculous. It's a security sometimes, and then sometimes it's not. No, that's a complete misreading of what she's stating. And also you need to understand, again, she's addressing what she had to address per her job based on what the SEC brought up here. And so then Attorney Morgan says, "The judge referred to the SEC's reply at pages 4 to 5, in which it alleges Ripple engaged in 3 categories of XRP sales and offers. And He highlighted another snippet which reads as follows. Finally, it is undisputed that Ripple engaged in 3 categories of XRP offers and sales, resulting in pecuniary gains. And then Attorney Morgan continues. It was not the judge who came up with these 3 categories. It was the SEC. It did so because the types of sales were very different from each other in critical respects. The judge decided to separately analyze and evaluate each of the SEC's 3 categories and referred to an authority. And here you can see there's another screen grab he shared, which reads as follows. The court shall separately analyze and evaluate each category of transaction. And then they cite a Marine Bank case for one of them. Attorney Morgan continues. Here is an extract of, is this footnote 11? I think he wrote in 11. Yeah, footnote 11. That's right. Here's an extract of footnote 11 from the Marine Bank case. Each transaction must be analyzed and evaluated on the basis of the instrument in question, the purposes intended, and the factual setting as a whole. And so then you got to ask yourself, is that what Judge Torres did? And I don't want to rehash all of that stuff. I've covered that pretty well and pretty in depth in recent weeks on that point. But you know, if you've been following and paying attention, even a little bit, the answer is obviously yes. The judge did that, as she should. And then Attorney Morgan says, hard to see error in the judge's approach in being efficient and analyzing and evaluating the transactions in question by reference to the very categories urged on her by the SEC itself. Very fair to the SEC. When she followed this approach and evaluated the 3 categories, she found significant differences in the factual setting. One significant difference is that institutional buyers signed contracts with Ripple. Buyers from programmatic sales did not. Now, let's pause and note when we're talking about programmatic sales, which again is the language that the SEC chose to use in this, which is why Judge Torres is using it. We're talking about transactions that would occur, for example, on cryptocurrency exchanges. You know, places where people like you and I might purchase XRP. Attorney Morgan continues. Another difference is that Ripple did not know who were buyers, and the buyers did not know Ripple was the seller in programmatic sales. Programmatic buyers did not know to whom they were paying their money. Further, the judge found that the evidence did not establish that Ripple made promises to programmatic buyers and that the evidence did not show programmatic buyers expected profits from Ripple's efforts rather than other factors. In short, the judge recognized that the factual setting as a whole between institutional sales and programmatic sales was very different. Further, her reasoning shows that a reasonable investor in the position of institutional buyers was in a different situation than the reasonable investor in the position of a programmatic buyer. The factual setting made this finding inevitable. The legal creation known as the objective reasonable investor still inhabits in each legal case a landscape of actual facts. In this case, the reasonable investor had different expectations in the very different set of facts in the different categories of Ripple sales and offers the SEC formulated. I don't see any error in the judge's reasoning. Sad ha for the SEC. And so that's a crack at Charles Gasparino, who, when he rips on people, he will then write sad ha when he's posting on X. And then he tagged Charles Gasparino, and I haven't seen a response from him to this point. But this is so spot on. And so that's why I said, in addition to the reasons that I've shared on this channel to this point from Attorney Jeremy Hogan as well as Attorney John Deaton, I just wanted to add this from Attorney Bill Morgan, XRP community member, because I think it does a great job of fleshing out an additional reason that I don't see why we here in the XRP community should be shaking in our boots over this stuff. And XRP does have legal clarity right now. So the question technically is just, is that going to change to the negative in the future? And while technically nothing's impossible on that front, I find it just infinitely unlikely. I do not believe for a moment that's going to happen. And there are a ton of reasons I've broken down in recent days, so I don't want to do it again in this video. But no. So here you have yet another reason. It's a good one. It's a fantastic one. So you guys let me know what you think in the comment section below, but I find it highly compelling and persuasive. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.